Hello friends, in the series on the income tax cases, today we will discuss the case of THIMMAREDDY KRISHNAREDDY versus income tax officer. This case has been reported in 85 ITAT Tribunal, short notes 22. The matter has been decided by Bangalore ITAT C bench and the date of the judgment is 4th January 2021. As all we know, that the period of filing the revised return has been reduced very drastically over a period of time. Earlier, the assessee was able to file its return of income and then revised return within 2 years from the end of the relevant assessment year. Then it was reduced by 1 year. It was done up to the end of the relevant assessment year, and now the assessee can only revise the return of income up to 31st December. Sometimes it happens that when the assessee has filed its return of income, the assessee come to know that the assessee has to claim any claim which was entitled to the assessee, but somehow he was not able to claim in the return. It may be because of lack of knowledge, or it may be by some mistake on the part of the person who is filing the return of income on the behalf of the assessee. So in that case, there is genuine hardship that how the assessee will file its claim, because the time for filing the revised return is not available with the assessee. Sometimes it also happens that when the scrutiny assessment is going on, then there is a landmark judgment of Supreme Court in Gupta, India, which says that the assessing officer cannot admit the new claim of the assessee until and unless the assessee has filed the revised return. Now the problem for the assessee arises that the assessing officer cannot give the claim to the assessee because the assessee has not filed the revised return, and the assessee do not have the time to file the revised return because the time has passed for filing the revised return. So these type of cases are the genuine hardship for the assessee. But in this present case, when the assessment order was passed and when the assessee was before the CIT appeal for other matters also, the assessee first time claimed exemption under section 54B, which is for the capital gain on the sale of the land which is used for agriculture purposes, first time. But the CIT appeal said that because the assessee has not filed the revised return before the learned assessing officer, that is why the assessee cannot claim the new claim, which was not in the original return. The assessee moved to the ITAT. The ITAT held that the case of Gupta, India is applicable only in case the proceedings are pending before the assessing officer. The case of Gupta, India says that the assessing officer cannot give a new claim which was not taken by the assessee in its original return until and unless the assessee has filed the revised return. So the crux is that even if the assessment proceedings are going on, the assessing officer will not be able to give the new claim to the assessee because the time for the revised return is over, and without revised return the assessee cannot claim the new claim. So the assessee has to wait up to the CIT appeal when the matter will go to the CIT appeal. So the ITAT said that the order of the CIT appeal, to the extent it denied the exemption under section 54B on the ground that the claim of the assessee is not available to the assessee since the assessee has not filed the revised return before the assessing officer, is not correct, and the CIT appeal should have given the claim to the assessee because the case of Gupta, India is not applicable in case of matter pending before the CIT appeal or the ITAT. So the ITAT reverted back the matter to the learned assessing officer for admitting the claim of the assessee under section 54B, because now the chain has been broken and the assessee has admitted the claim before the CIT appeal. Friends, I find this whole process very cumbersome and very lengthy and very litigation because in these type of cases, the assessee has to first go to the CIT appeal. And generally we have seen that the CIT appeal do not give the relief on these type of matters. So before the assessing officer, assessee cannot claim. CIT appeal will not give. So ITAT gives the relief and then it reverts the matter back to the assessing officer. So all this process takes near about 5 to 6 or 7 years. So it is very cumbersome process for the assessee. But this is the law. At the end of this video, once again I am repeating the name of the case. The name of the case is THIMMAREDDY, KRISHNAREDDY versus Income Tax Officer. And this case has been decided and reported in 85 ITAT Tribunal at short notes 22. And the date of the judgment is 4th January 2021. Thank you, friends.